I don't know. I'm getting
I
it.
don't even know.
Should be on 1080. I think it's on 1080. Yeah.
That's why I hate fucking porn. Space. The bottom ones are fine. Well, I don't see shit, so.
What if you come out of my camera to your camera?
I'll try that. Let me try one more function.
You want to stand over here?
You need help.
No.
We got audio? There's no audio.
Huh?
No audio.
Out of the speaker?
You heard something.
Well, he's got his net mic on. Y'all see that? It's only channel 2. Is it? I only use channel 2.
No, I don't. Sorry? So you said.
Yeah, I got it now.
Chelsea? You want to change something?
Channel 1, yeah.
It's great to figure that out, like, as it's happening. What happened?
Yeah, I got it.
I don't want to wear anything. I want to.
Super low.
Tired.
I haven't shown that one right now.
I got it.
Is good?
Just talking.
It's really low, but they haven't really spoken yet, so. Okay, let me know.
I'm not talking. Right. Exactly.
All rise. Circuit Court National Order, and will Don Jingles presiding.
Good afternoon, everyone. Please be seated. And council, if y'all could approach just a moment, just from a scheduling perspective. Let me turn that down. It was not. Let me see, home. Ah, here we go. All right, what do I do? Where? Oh, right here. Thank you, Trevor. All right, let's see if that helps. Good God. All right, let me try it again. Let's step in the hallway. I just can't do that to everybody. It's just really loud.
Focus on the name for now. I'm getting this, because this is obviously a big deal. I'm getting the vibes that they will have us ditch after the name, especially because the guy is in person.
Yeah, it's going first. Might be the right call.
Yeah.
This might even be there. Oh, man.
But yeah, C is at breaking news right now. They're talking about calling one of the Nightsiders in for like a swing shift because there's so much going on right now. They're also talking about pulling Jeff Deal off of Action 9 after he's done his interview today and having him go to something. Because
They should.
yeah,
All hands on the deck.
yeah. Yeah, just keep me posted.
Were you first pregnant?
No, I was a lot barely. No, I was. What was I? 20 years ago. I was in 7th grade.
How old was that of age? Sorry.
30. No, I was in 6th grade. 30.
And I did have
No,
two motions to sever, one on, and let me just say it on the record, and we are on the record now. State of Florida versus Jerone Hunter, 2004-1380. And then, of course, we have State versus Victorino, and that is 2004-1378. I do have motions to sever, and there have been motions to sever from the beginning of the case forward. Both motions are very well written. Do you want to add anything to what, other than what you set forth in your motion, Mr. Wood?
Judge, I don't have any additional legal argument in there. Of course, emphasize the importance of where we're at right now with your honors going through the process of considering our life without the possibility. So, no additional argument.
All right, thank you. Ms. Simmons?
No additional argument.
All right, thank you very much. So I am going to very respectfully deny the respective motions to sever, and then we're going to move forward with the Spencer hearing. And counsel, how best would you like to proceed?
I can put on the record first, Your Honor, that the state does not intend to introduce any additional evidence at this time, and we will reserve most of our argument unless I have to rebut something today for the sentencing memo.
All right, thank you very much. Mr. Wood?
And we have on Zoom Dr. John Discerning.
All right, and got it.
Dr. Discerning, can you hear us okay? You're on mute.
Oh, and I just want to state for the record, we do have Mr. Hunter present in the courtroom, and Mr. Victorino is present by Zoom.
Yes, Your Honor, and I did verify that he can hear us and see us. So,
Thank you.
So he can, he's able to actually participate.
Thank you very much.
Dr. Discerning, can you hear me okay?
Yes, sir.
Okay. Would you state your name for the record, please?
Certainly. It's John Dzurney. That's D-S-U-R-N-E-Y.
Bless you.
And thank you, Doctor. What do you do for a living, sir?
A clinical neuropsychologist.
And for yourself or for a company or what?
For myself. I have my own practice.
All right. For the record, where's your practice located?
Tampa, Florida.
All right. And how long have you been well, first of all, are you licensed in the state of Florida as a neuropsychologist?
The subspecialty of neuropsychology is not an individual license. I'm licensed as a psychologist, as are all other neuropsychologists.
Okay. How long have you been practicing in the field of neuropsychology?
Approximately 20 years.
Okay. And can you provide the court with your educational background, please?
Yes, I received my undergraduate degree from College of Rutgers University. Then I took some master's level work at University, and then I received my master's in clinical psychology and my PhD in clinical psychology from Nova University.
Okay. And when was that last degree? When was that?
91.
Okay.
90 or 91. I have to, I'm sorry. It's been a while, so I forget. So, it was 91.
All right. And have you previously provided or given an opinion as an expert in neuropsychology on any prior occasion?
Yes, sir.
And when was that? Or how many, well, when was that and how many times?
I've given opinions multiple times. I would have to go back and look, beginning several years ago.
Okay. And for, I don't need specifics on each case, but generally, what types of cases were you providing expert testimony?
Either competency or competency to proceed, and then also occasional personal injury, and then also mitigation work.
Okay. Have you, in your expertise and prior work experience doing competency matters, was that in another state?
No, that's in Florida.
Okay.
Well, actually, let me correct that. Years and years and years ago, when I was in New York, I did testifying commitment hearings as part of my job as a psychologist at the county hospital.
And on those occasions in New York, were you retained or hired on behalf of the defense or the state or both?
The state, I was employed by the county, so I was representing the state.
Okay. And have you, prior to this case, provided expert opinion in any prior criminal case or capital murder case, and/or capital murder case?
I've seen other cases. I was retained in other capital cases, and I would have to look to see whether I testified or was deposed.
Well, either way, you were under oath to tell the truth in either occasion, deposition or court?
Yes, sir.
Okay. So when did you become involved in this case?
That would have been, let me just check my records. That would have been back in, I believe it's March of 2024.
I have a deposition from 2023.
Oh, it might have been 2023. Let me look. Oh, I'm sorry. Yes, it was 2023.
Okay. And did you have occasions to, well, before I go on, are you licensed in psychology in any other state?
I have been licensed, most of my I've been licensed in New York and Georgia, but both of those licenses are currently inactive.
Okay. Have you published articles in your work as a psychologist or neuropsychologist?
Yes, sir. Published in peer-reviewed journals, authored poster presentations, oral presentations at national and international conferences.
And were those on the subjects of either psychology or neuropsychology?
Most of them were on traumatic brain injury with neuroimaging and or neuropsychology.
Okay.
And I apologize to interrupt, Mr. Wood, but I have 3 people trying to watch the next of kin. They were given a Zoom link.
Oh.
So I'm just not sure that we're on the correct Zoom link, or we didn't give out the correct Zoom link.
I can give it to you. Or I'll give it to you, that we can be exempt.
Please.
Thank you, Steve. Go ahead, Mr. Wood.
Thank you, Your Honor. So the next question I would have for you, Dr. Discerni, is for the purpose of review in this case and to assist you in your evaluation of Mr. Hunter and various matters in your field in this case, did you receive any materials to review in this case, and have you reviewed?
Yes, I've reviewed, let me just go back. So I've reviewed prior depositions from the initial trial by the experts, as well as other discovery provided by defense, as well as the recent deposition of Dr. Herzog.
Okay. Did you also receive a copy of your deposition?
Oh, yes, sir.
Okay. Did you also receive like the Department of Corrections records?
Yes, sir.
Okay. Any other records that you recall that you received?
I'm just going to take a quick look here. No, they're mostly reports and depositions, and I did receive some raw data from Dr. Herzog.
That was actually my next question.
Oh.
We'll get into that in just a moment, but when you, for the benefit of the court, what are you talking about when you said you received raw data from Dr. Herzog?
He sent the handwritten protocol for the California verbal learning test that he administered, and he also sent the computerized scoring printout.
Okay. And did those materials that you outlined assist you in your formulating an expert opinion in this case and your testimony here today?
Not particularly. There was nothing that was all that strikingly different.
Are you referring to Dr. Herzog's testimony or the other?
No, in the raw data.
The raw data, okay.
Yeah, the Dr. Herzog's testimony has influenced or was used in the preparation for the opinions I'm offering today.
During the course of your involvement in this case, did you have the opportunity to meet personally with Mr. Hunter?
Yes, I have.
And when was that?
Let me just go back to my records for a minute here. That would have been looks like that would have been on the 9th.
Of what month and year?
I'm sorry?
What month and what year?
Oh, sorry. I'm sorry. The 9th of, it looks like that was the 9th of March, 2023.
All right. And
Yeah, actually it was I'm sorry, it was the 8th.
and what other occasions?
And then I met with him, looks like it would have been on the 6th of April, 2023.
All right. Now, and this was this at Union Correctional that you met with Mr. Hunter?
The first date was at Union Correctional, and I believe the second date was at the Volusia County Jail.
Okay. So, and what was the purpose for meeting with Mr. Hunter as far as what your intentions and what your plans were with regard to?
I was asked to evaluate his cognitive abilities and to evaluate any impact of those on his actions and behavior.
Okay. And on the occasions that you mentioned, was there testing done on Mr. Hunter on both occasions?
I believe so, yes.
And did you conduct more than one test on Mr. Hunter?
Oh, yes, we conducted a full battery of neuropsychological tests.
I won't ask you to name each one, but can you give an idea, approximate, or an exact number of, over the 2 times that you met with Mr. Hunter, how many tests were performed or evaluations were done on him? Less than 10, more than 10?
Oh, more than 10. So, 1, 2, 11. Looks like 12, what we call psychometric tests, and then there were several other neurobehavioral, what we call sign tests, in terms of just having him do things that were more idiographic, where either he can do them or not do them,
Okay.
rather than being compared to a norm.
I'm going to focus on one particular test that was performed. According to my notes, you did conducted the California Verbal Learning Test, second edition.
That is correct.
Okay. And what's the purpose of that particular test? What is it a test?
It's a list learning task and assesses basically memory, memory acquisition, retention, recognition for verbal memory.
All right. Is it a test where you orally ask questions of Mr. Hunter, or does he have to write something out or fill something out?
No, it's completely orally administered. He's read a list of words. At the end, he's asked to recall as many of the words as he can, and there are 5 trials like that. And then, I'm sorry?
Within the 5 trials within the test?
Within the test, there's 5 trials, 5 learning trials. Then there's a distractor list, or a list of alternate words. And then there are a recognition or recall trials that are for immediate and delayed recall, or a short-term and delayed recall. And then there are recognition trials. Can he recognize the words? And then there's also a forced choice section, which really is not memory. That's more of a validity indicator that's embedded in the test.
Okay. To see if the the subject is giving best effort, or feigning, or exaggerating?
Exactly.
Okay. Did you, before I go on, did you see any indication in that particular test, or your testing of Mr. Hunter overall, of any feigning or exaggeration or, manipulation or malingering?
No, sir. He put forth full effort, and all of the embedded and standalone effort measures were consistent with full and adequate effort.
Okay. And is that a particularly long test? Does it take a lot of time to do?
Well, yes, it's the initial trial. There's the initial trials, and then there's a alternate word list that's read, and then there's a recognition or recall trial. Then there's a 20-minute delay, and then there's a second recall trial, and these are there's both free recall and cued recall.
Okay. And regarding the results of that particular test, can you tell the judge what your raw data, what your testing data disclosed with regard to that particular test?
Certainly. Let me just, if I can just refer to my notes for a minute. What we saw was that there was generally average to low average performance acquisition, and then there was average to low average recall and cueing, or giving categories of words to help him recall the words. Didn't in this case did not aid the memory, which is and I'll point out, is different than the results that Dr. Herkoff found.
We'll get into that in just a few minutes, but
Okay.
so so what did you see on the test that you, in terms of the data, that was a low average score, or resulted in a low average score?
It was mainly variations within learning trials. Sometimes he was, I mean, they were all at the lower end of average. Sometimes they would go into the below average range, depending on the particular trial. So there was variability in his learning slope.
Was this test related to ascertaining what we would call executive functioning?
Not exactly. This is more of a memory test. Now, there are executive aspects of memory, but this test is more of a memory. The cueing is a categorical aspect, which is an executive function in theory, but this does not have aside from the attention, does not have a particularly heavy executive function component to it.
Within that testing or other testing, did Mr. Hunter indicate below average for processing speed?
On the IQ test, his processing speed the processing speed index fell into the below average range.
Okay. You mentioned previously in your deposition about verbal abstract. What is that?
Well, there's a measure on the IQ test on the WACE for verbal abstraction, the ability to see similarities, things that are not direct. So, for example, the sample is, what way are a horse and a cow alike, for example? And a abstract answer would be they're animals. But you could have a concrete answer such as they have 4 legs, they have hair, things like that.
All right. So, as far as the testing, and by the way, were there any other tests that you saw on the raw data that Mr. Hunter was below average?
There was one, I believe there was one other processing measure that was below average. Yeah, it was in the below average range. That was the trail making test part A.
I'm sorry, could you repeat that again?
I'm sorry, that was the trail making test part A was in the below average range.
For the benefit of the court reporter, is that trauma or spelled differently?
Trail making,
Trail making, okay.
right. Tango, Romeo, Alpha.
Yeah, it just on mine, it just sounded like, and I have that in my notes. So, tell us about that. So what's that test for?
It's a very simple test of really psychomotor speed. There's a motor, there are a series of numbers, and the examinee has to draw a line connecting the numbers in order as quickly as possible, and they're distributed around the page and not in a direct sequence, so they need to follow the sequence around and search for the numbers.
Okay. And I think one of the tests that you did was labeled controlled oral word association.
Yes.
And how did Mr. Hunter do on that test?
Let's see here. I believe there was some discrepancy. On phonemic fluency or production of words based on the sound. He was in the below average range. And when we looked at category fluency, it was mildly impaired. And those are associated with executive dysfunction.
Okay. And could you explain a little bit more in terms of Mr. Hunter's ability to take in information, understand and process information? What are we talking about here?
Well, that's more the ability to sort of categorize and determine differences between bits of information quickly, so that he's able to either develop categorical understandings or some other method of grouping things together and provide that information.
Okay. Did you, in the other testing, any other deficits that you noticed in the testing that you did?
The primary deficit, as we discussed, or I discussed in my deposition, was the verbal abstraction. There's some indications of slower processing speed, and the controlled oral word association test that was impaired. There's also other indications of some slower processing on the Stroop test, although the main purpose of the test, which is response inhibition, was average. So those are the primary findings from the examination.
That doesn't look like a mini doodle.
I'm sorry?
Yeah.
Hold on.
Is my dog? Oh,
No,
see.
you're fine, doctor. It's all right.
Okay.
Bless you.
Let's see.
I apologize. Amber is a vet tech, so I suspect it was her.
May I proceed, Your Honor?
You may proceed.
Thank you. Doctor, so in kind of breaking your data and interpretation of the data, evaluating the data, in terms of Mr. Hunter's, when you talk about processing speed, is that being able to consume or take in information and understand it or process it quickly or slowly, or is there kind of a layman's way you can explain that? Doctor, can you hear me? I don't see the mute thing. Doctor, can you hear me?
That we are.
Doctor, can you hear me?
Yes, sir.
Okay. I'll repeat it. Did you hear my question to you?
I do not believe so.
Okay. Let me repeat it. So in terms of like a layman's interpretation of the verbal abstract and the processing speed, if you could explain to the court as it applies to Mr. Hunter, does he have Mr. Hunter have an impairment, in your opinion, about to take in verbal information and be able to process it, mentally and understand in real time, what's going on?
In terms of concrete information, and the things that would be at issue, in terms of understanding language, responding, being able to manage concrete information, there's really no impairment there. It really is in the more abstract ability to understand abstract concepts and to see sort of the larger picture, and be able to understand how the individual actions may influence other occurrences down the road.
So you're talking about being able to process and understand the repercussions or the net effect of his actions? Is that what you're talking about?
Yes, and basically yes.
Okay. In your opinion, does that interpretation apply to his actions in this case, his impairment to understand or process the long-term consequences of his actions?
Yes, and not just the long-term consequences of the action, the magnitude of it, but also to be able to understand how things might transpire. For example, during my deposition, I used the example of frying a turkey. You know, you go out, you fry a turkey, great, but you don't, if you don't have an abstract understanding of everything that's involved in that, you don't realize the inherent danger and how it could go wrong. There's a difference between using a chain to lower the turkey versus using a rope or a nylon cord. You know, concretely, you're doing something to lower the turkey.
Hello.
All right, I think that we're gonna have to,
I understand. Judge.
thank you. I'm gonna ask that she just be removed, and if you can let her know why. Thank
Will do,
you.
Judge. Apologize.
No apologies necessary. Thank you.
Thank you, Judge. And I certainly don't want to miss anything. Is that your, so the example of frying a turkey and the consequences of not doing it properly and the dangerousness of doing that, is that kind of where you were going with regard to Mr. Hunter's abstract thinking or verbal abstract thinking in this case?
Yes, it's not just a matter of doing it properly, it's being able to anticipate the things that could go wrong. And that's what gets us into the abstract understanding of the activity. People when they're able to, or when they're not able to abstract, they don't really. It's harder for them to anticipate the consequences of what they're doing, and I don't mean concrete consequences, but the downstream implications, or what could go wrong, and that's the same people are like, what could possibly go wrong. That's what requires abstract thinking, is the ability to see the greater picture of that particular activity. And his ability is, compared to his other functions, that's a significant weakness in terms of his cognitive functioning.
So, kind of moving on, you talked about, you received from Dr. Herkov his separate testing on the CVLT test?
Yes.
And which version was that?
He used the most recent version, the CVLT-3.
Is there any, let me ask it this way, what's the difference between the second version and the third version?
Primarily the normative sample, the main reason that at that time we used the CVLT-2 was, although the CVLT-3 had been out for several years, I believe it came out around 2017 or 2018 perhaps, the platform on which the CVLT-3 was scored was remote. So you had to go into a website which was actually housed in Canada to score the test. And they did have a paper version, but you had to put it into the scoring program, which was online. And since at that time I was doing a lot of federal work, we were prohibited from having data stored outside the United States. So my practice did not use any of those instruments that had the data stored outside the United States, which was why we used the CVLT-2, because the stimulus is primarily the same. There's I think there's a difference in the forced choice, but the word lists are the same. And it's just a more updated normative sample.
Okay. So, having reviewed Dr. Herkov's raw data, does his data on the CVLT test change your opinion, alter your opinion with regard to the opinions you've been providing here today?
Well, his testing shows a much more impaired learning. So what he shows in terms of the updated sample, because the raw scores were not particularly different, but what they did show is that initially Mr. Hunter was able to recall an appropriate number of words and was average, but then didn't learn as quickly as he would have been expected to. So his scores actually declined as he was presented with multiple trials.
Okay. And are there, with regard to testing on a particular individual, are there things? Well, let me ask it this way: can things like fatigue, lack of sleep, stress, noise, can any of those affect the data outcomes in any particular test?
Oh, definitely. I mean, one of the fatigue is a very significant problem. Noise, distractions are a problem. Other, interruptions or other people present during the examination. There's a large literature on what they call third-party observers, which impacts the data as well.
Okay. With regard to those examples I just gave you, did you see from your observations on the times that you spent with Mr. Hunter any signs of fatigue or stress or refusal to do the test or anything like that?
I mean, he did put forth good effort. The issue is that we tested him over an entire day. So we tested him for a couple hours in the morning. He took a lunch break, and we tested him for a couple of hours in the afternoon. So it's a long day. He was in prison, which is a stressful environment. And for at least some of the tests, he was cuffed. So we're probably not. There are probably factors that come to play that cause variability in the testing. But all in all, I would consider this to be a valid assessment of his functioning, because there was no significant fatigue where he was, unable to pay attention or things like that. He was very cooperative and exhibited good motivation throughout the testing. So I would not consider. So I would consider this rather a valid assessment of his functioning.
Okay. And on the last subject, I'm going to ask you a few questions about. If past his prologue, what is your hourly rate in this case?
$300 an hour.
Okay. And do you have an estimate or an exact figure of how much you've charged the JAC so far for your involvement in this case?
For let's see. I guess since, are you talking about the initial trial or just the more current?
You're talking about the 2023 involvement?
Right.
Yeah, go ahead and, it's up to you if you want to break it down or something like that.
Okay. Let's see. 2023. Let me find the total here. I think it was here's the invoice. Okay. Let's see. So getting bogged down in JAC billing here.
We all do that.
Yes. I want to say it was around, $8,000.
Okay. And then, what are we looking at for this year's resentencing and involvement?
Okay, we, billed them in April for, $1,691.85. And the anticipated billing, including today's, testimony, is gonna be around $3,000.
Okay. Were you ever asked by myself, anybody on behalf of the defense, or anyone to alter or change or manipulate any of your testimony or opinions or any acts you performed in this case?
No.
Okay. And would you have done so simply because you're being paid?
Oh, I'm an advocate for the data, sir.
Okay. I don't have any other questions, sir.
Thank you.
May I inquire, Judge?
You may.
Good morning, Dr. Discerning.
Good morning.
You did not testify before the jury in this case, right?
That is correct.
You've only testified in one other death penalty case, and that was for the defense, correct?
I believe that is correct.
In all of your work in the legal system in Florida, you've never been retained by the state attorney's office, is that correct?
That is incorrect. It's more recent, but I've been retained on, I think, 4 or 5 cases in the last month by the state attorney's office.
What state attorney's office?
The 6th District.
And for what purpose?
I believe they're all competency.
So in the realm of death penalty mitigation, at least, no state attorney's office has consulted with you, correct, or hired you? If that's correct?
Yes.
And then at the time of your deposition, no one from the state attorney's office in Florida had consulted you for any reason, but you're saying now in the last month, 6 have consulted with you, is that right?
That's correct. There was a training in order to, you have to go through in order to be retained by the state attorney's office. And I did that training maybe 6 months ago or so.
You have not reviewed Jerone Hunter's prior trial testimony from 2006, is that correct?
No, I do not believe so.
You have not reviewed the interview he gave to the police, correct?
No.
You have not reviewed witness depositions, is that correct?
I've reviewed professional or expert witness testimony.
Right. So the only depositions or prior trial testimony you reviewed has been related to the experts, correct?
Correct.
Did you review Dr. Reep's Ames depo?
I believe so. Let me just check. Yes, I did.
How about Dr. Herkov?
Yes, I did.
Okay. Did you get a transcript of his trial testimony, or did you just rely on his deposition testimony?
To whom are you referring, ma'am?
Dr. Herkov.
I just have his deposition. I don't have his any trial testimony.
You met with Hunter 2 times, is that correct? Or over 2 days, but multiple times on one of the days?
Right. One day we met with him twice, and on a third day we met with him 1 time.
Was that recorded?
No, ma'am.
You're saying a we. Who was present with you?
On at least one of the occasions, my technician was with me.
So no attorneys for Mr. Hunter, correct?
No.
Did Hunter admit to any of the murders to you?
No, ma'am.
Did you talk to him about what he was thinking that night?
I do not believe so.
Or the events leading up to that night?
No, I read Dr. Harper's deposition, who went into great detail about that.
So no, you didn't talk to him about the events leading up to the murder?
He mentioned that he was living with these people and were gonna go back to get some of, I believe, Mr. Victorino's belongings, and that they had been, I believe, using drugs and perhaps alcohol. But that was vaguely all he said.
Is that what he said to you, or that's what you read in Dr. Harper's deposition?
I'm not sure which is which in recollection, what he actually said versus what was in the deposition.
Well, did you ask him what happened during the murders?
No.
Did you ask him what he did after the murders?
No, ma'am.
Did you ask him what he was thinking after the murders?
No, ma'am.
Or about what he thought of the consequences of bashing someone in the head with a bat, things of that nature? Did you go over any of that with him?
We discussed, no, ma'am.
When you were meeting with him, was he able to focus and participate in the testing with you?
Yes, ma'am.
Was he able to communicate effectively with you?
Generally, yes.
Did he appear to be talking to someone who wasn't there?
No, ma'am. There were times where he would become or lose his focus, but he didn't appear to be responding to internal stimuli.
Okay. Now, you did administer, would you agree, almost 60 different data points?
Well, I don't know offhand, but the tests generate multiple data points, so it may even be more than that.
Is it fair that out of those, over 50 fall in the average or low average range?
Yes, which is actually striking when we see something that is so far out of that range that becomes very important.
Would you agree with me that that's not indicative of a deficit?
No, ma'am, I would not agree with that.
I want to talk briefly about some of the testing you did. So the Wechsler Adult Intelligence Scale, that's the test of his general level of intelligence, right?
Well, it measures many things. One of them is a general IQ measure, yes.
And his result was an average result of 96, is that correct?
Which score are you talking about?
Did he achieve a full-scale IQ of 96?
Yes, but that is not a unitary construct.
Okay. Well, the full-scale IQ of 96, does that place him in the average range of measured intelligence?
Again, yes, but that is not a unitary construct. So what's happening is it's not actually an overall accurate measure of his intellectual functioning.
You administered the brief visual memory test, correct?
Correct.
And on this test, his visual learning and recall was average and in some cases into above average, correct?
I believe so, yes.
The delayed recall was above average also, correct?
It was at least average. It wasn't, it might be above average. I'd have to look. If you'd like, I can do that.
Yeah, take a look. If you want reference, you can look at your deposition, page 19.
I've got the data right here. The delayed recall, yes, it was above average. Yeah.
You administered the complex ideational material from the Boston Diagnostic Aphasia Examination, is that correct?
That's correct.
And that's like a verbal comprehension test, is that correct?
Yes, it's a test of assessing comprehension of verbally presented sentences in short paragraphs of increasing and complexity.
And he did average on that test, correct?
That's correct.
You administered the Stroop test, right?
Yes, ma'am.
And on the executive functioning aspect, the ability to inhibit behavior, he scored average there, correct?
As I stated earlier, there was a indication of slower processing, but the executive function measured by that test were intact.
Right, his ability to inhibit his behavior and control it was average, right?
That's not exactly correct. The score on that test was average. There are a variety of measures of one's ability to control and inhibit behavior. That's just one of them.
Right, and so on this one, he did average.
On that particular test, yes, he performed average.
You administered the wide range achievement test, right?
That is correct.
And everything was broadly average with the exception of math computation, which was below average, correct?
Correct.
You administered the complex motor tasks, correct?
Correct.
And that's executive functioning related, right?
That is correct.
And he had no error in reciprocal coordination, right?
No, I believe the error was in response inhibition.
Right, so he had no error in reciprocal coordination, right?
The error was in response inhibition.
Right. So, and his performance on the graphomotor control was pretty good, right?
I believe so. As I stated, the problem with that, the finding on that exam was problems inhibiting motor behavior.
You administered the, I may not say it correctly, the Retan-Clove test?
Retan-Clove sensory perceptual examination. Yes, ma'am.
Visually, he was fine, right? No indication of impairment?
Let me take a look. Are you talking about gross confrontation to visual fields?
I'm referring to your deposition, page 23, if that will assist you.
Okay. Well, let me take a look at the data.
Sure.
Yes, the visual fields were intact to gross confrontation. That's correct.
Okay, we're going to move on to the booklet category test. That
Well,
test-
but ma'am, let me just say, I believe you're leaving out the positive finding that there were suppressions.
Dr. Discerni, if defense counsel wants to get up and ask you any follow-up questions, he can, but please just answer my question. The booklet category test, that test measures problem solving and concept formation, correct?
Yes.
And that's an executive task, is that right?
Yes.
Hunter achieved an average score, correct?
Correct.
The grooved pegboard, which measures fine motor dexterity, was his score average there too?
I believe so, yes. Actually, let me just look really quickly. Since you'd like me to answer your questions, let me make sure I'm doing them accurately.
Thank you.
They were, the T-scores were average, but there was one error in the dominant hand.
And you administered the speech sounds perception test, is that right?
Yes, and the seashore rhythm.
And the speech sounds perception test, that measures the persistence in terms of attention, is that correct?
Yes, that's correct.
And it also assesses sensory auditory processing deficits, right?
Only central auditory processing deficits.
And again, Hunter's performance was average, correct?
Correct.
And the seashore rhythm test, that's a faster version of the previous test we just discussed, right? But with reduced structure?
That's not exactly accurate.
Is that what you said in your deposition?
I'm sorry, ma'am?
Is that what you said in your deposition?
I can go back and look, but it does have reduced structure and it is faster, but it's not the same type of test. The stimuli are quite different.
Is it by comparison a faster test with relatively reduced structure, and that's a more pure attention test, and that actually was above average? Does that sound about right? I'm referring to your deposition, page 25, if that assists at all.
Speech sounds perception test was average. The seashore rhythm was above average.
Okay, so his performance was above average on the seashore rhythm test.
Correct. Yep.
You administered the paced auditory serial addition test, is that correct?
Yes.
And that measures attention and working memory, right?
Primarily working memory, but yes, there's an attentional component to it.
And Hunter was average?
Yes, he's not really demonstrating any attention problems.
The judgment of line orientation test was also given, correct?
Correct.
And he only made one error on that, is that correct?
That's correct. That was perfectly within normal limits.
You determined that Hunter was ambidextrous, is that correct?
I believe it was mixed dominance, but let's look.
I'm referring to page 26 of your deposition, lines 10 through 11, if that assists.
Oh, yeah, let me go back and look. I just don't remember whether it was ambidextrous or mixed dominance. And I'm sorry, you said page 26?
Yes, sir. Your full answer starts on line 6, if you want to read through 11.
Oh, yeah, okay.
Did you determine that he was essentially being ambidextrous?
That's what it appeared to be. We did not do dominance testing, but it appeared that that it was incomplete dominance or incomplete lateralization, and it appeared to be ambidextrous.
Okay, thank you. You're not testifying that Hunter's capacity to appreciate the criminality of his conduct was substantially impaired, correct?
No.
You're not testifying that he was under the influence of extreme mental or emotional disturbance, right?
I haven't offered an opinion regarding that.
Okay. And would you agree with me that Hunter knew that if he bashed a person's skull in with a bat, that they're likely going to die?
I didn't offer any opinion related to that.
So you can't offer an opinion about whether or not he would know, bashing someone in the skull, that they would likely die? Is that what you're saying?
I don't, A, know that that's true, and B, I am not prepared to offer an opinion on that.
How about whether or not he would know if he killed someone, he may go to prison?
I'm sure he's aware of the penalties for crimes.
No further questions.
Brief follow-up, Judge.
Yes, sir.
Dr. Lynn, let me just follow up on some questions and then, and we'll be done. So, Dr. Harper, the doctor you referred to, she's a psychologist?
Yes, she's a forensic psychologist, I believe.
All right. And your role in this case was strictly to do an evaluation on Mr. Hunter as a neuropsychologist and do neuropsychology testing?
That is correct.
Okay. Now, you did receive, Dr. Harper's deposition, you testified to that, correct?
That is correct.
And in that deposition, there's a narrative where Dr. Harper did, in fact, talk to Mr. Hunter about the events in question, correct?
That is correct.
And would the same be true with regard to Dr. Herkov's evaluation in time with Mr. Hunter, where Mr. Hunter talked about the events, the murders, the burglary, all that?
I do not believe that was part of Dr. Herkov's deposition.
All right. In your role, your narrow role in this case, were you ever tasked or asked by the defense to ask Mr. Hunter of the murders, the burglary, the events in question in this case?
No, sir.
Okay. When you do an evaluation on a client, other than, well, in general, do you record your evaluations with your patient?
No, sir.
And you do, in your practice, routinely meet with live patients, right? You do interviews, testing, all that?
Yes, sir.
Why do you not record your time with the client?
Well, there's a substantial literature on recording third-party observers having an impact on the validity of the testing.
In what way? That they might say something to please the third party, or am I getting it wrong?
Well, they may, depending on the nature of the situation, they may put forth, extreme effort, or they may act some way differently than they would in a normal, in a non-observed situation.
Okay.
It can also increase anxiety, which might impair their functioning to some extent.
Is it important for you in conducting testing and evaluation to have the client be, as much as you can control the situation, to be under less stress, to be able to have an environment where the patient can answer questions in a more relaxed setting?
Yes, there's an optimum level of anxiety that is required to keep people attentive to the task. And once we go beyond that, it's referred to as the Yerkes-Dodson curve. Once we go beyond that, it impairs their performance dramatically.
Okay. In this particular case, I was writing a note down. I wrote down, were there times when Mr. Hunter, when you're spending the time with him, that I think you mentioned it appeared that he had lost focus, was losing focus? Have I got that correct?
Yes, there were a couple of occasions where he would, I don't want to say drift off, but would just sort of, it wasn't during task, it was during periods between tasks where he would just sort of drift off.
Okay. And were those like long periods of time, short periods of time? How would you?
Less than a minute usually.
Okay. Were there, when you made those observations, did you interpret them to be signs of fatigue, or was like there's yawning or anything like that?
There was no yawning. The question of whether it was fatigue. He also did report, and I don't believe this occurred during the testing, but that he did hear his brother's voice on occasion.
I'm sorry, that he did hear his brother's voice on occasion?
Yes, sir.
And was that on the same day, different days? How did you?
Well, I had asked him about that, and because I questioned about whether the voice was inside his head or outside his head, and he said it sounded like it was inside his head, and he recognized his brother's voice. That did happen on occasion.
When you had those times, did Mr. Hunter, did his demeanor change at all? Did he seem to get angry, or any behavioral change you saw when you saw this or made this observation, had these discussions?
No, sir.
Okay. I don't see, were they on, you went out to see Mr. Hunter on 2 different occasions. Were they those times when you said he was talking to his brother, did they happen on both days, one day?
I believe it was both days, but I just asked him on one occasion, during one of the incidents, and he told me about his brother's voice. I didn't pursue that on the other incidences.
I want to go to what Ms. Dragonis was asking about the general of the full scale IQ. You had mentioned that there's subsets of that Wechsler IQ testing that did you notice any deficits or below average subsets within that IQ testing?
Yes, and the IQ test is it's basically a four-factor subtest. You have the overall IQ, and then if there are discrepancies within or among the index factors, that would indicate that the full scale IQ is not an accurate measure, because it's hiding variability within that measure. So then, and if there's no variability among the subtests, we then look to, or actually whether there is or is not, we then look to the individual factors, the verbal comprehension index, the perceptual reasoning index, the working memory index, and the processing speed index, to see if those are in fact unitary constructs. In other words, all of the subtests that make up those indices are roughly the same. And in the verbal comprehension index, which comprise of the similarity subtest, the vocabulary, and information subtests, that index is not a unitary construct, because there is a significant weakness in one of those measures, that being the similarity subtest, which does measure, as we talked about, measures the verbal abstraction, and that test is markedly different than all of the other subtests. It's a significant weakness in that group of tests.
There's a significant weakness for Mr. Hunter in that verbal abstract subtest?
No, it's actually a significant weakness for the population.
Okay.
We look at whether something's a relative weakness, i.e. it's just a weakness, for Mr. Hunter, versus whether it's actually below average or impaired for the general population. And his just to give you a sense of this, the scaled scores, which is what we use for the subtest scores, the average is 10, and there's a standard deviation of 3. Mr. Hunter's score on the similarities was a scaled score of 6. So he's more than 1 standard deviation below the mean of the population, not for himself, but of the population used to standardize that test in the ability to engage in verbal abstraction.
Okay. And I wrote this down too. There was in the response inhibitor testing, there was an error in that. Did I get that right?
Yes, that's, yes, I wasn't able to continue on about that. There, in the, I believe that was the Luria complex motor test, there's multiple things we look at to evaluate various aspects of executive functioning. 'Cause executive functioning isn't one thing, it's a group of abilities that we sort of address as quote executive functions. One of them is to smoothly follow patterns and with reciprocal coordination. The other is your ability to inhibit your behavior, what we call a go no go task, and that's where the error occurred when he didn't inhibit his behavior in the go no go task.
And that's a motor skill function?
I'm sorry.
Was that a motor skill function? Is that what you're talking about?
It's an executive function.
Okay.
It's not motor. Yeah, it's not motor skill. It's actually it's an inhibitory function.
And in layman's term, what does that mean for Mr. Hunter?
Well, it means that he's going to have the potential for not being able to inhibit a previously learned behavior or a behavior that's ongoing. So he'll lose the set and respond when he shouldn't. Or to give an example of the test, it's really a matter of the standard response is somebody holds their hand in the air, you say go, and you have them hit the desk and come back up. In this case, the response set is the opposite. When you say go, you want them to leave their hand alone, and when you say stop, you want them to come down and hit the desk. And so he was unable to inhibit the go behavior, which is the learned technique. When I said go, he started to drop his hand.
Okay. Does that tie into his diminished verbal abstract thinking in terms of processing information and responding to it?
They're connected because those are all executive functions in terms of response inhibition and verbal abstraction are all executive functions. So when you put the whole picture together, you've got somebody that's not able to fully understand consequences of, again, not concretely, but to understand the full picture in an abstract sense, and then has problems inhibiting his responses, combined with a slightly slower processing speed.
Okay. That's all I have. Thank you, Doctor.
Oh, certainly, sir.
May I release the doctor?
No objection from the state.
No objection.
Sir, thank you very much for your time.
My pleasure, Your Honor. Thank you.
Sir. Any additional witnesses, Mr. Wood?
A live witness would be Mary Bonson. Please raise your right hand. You swear or affirm?
He's on the stand for her, tell the truth, all the truth, nothing but the truth, so help you God.
Yes, I do.
Right this way, please.
Good morning.
Good morning.
Thank you. Mr. Wood, you may proceed, sir.
Thank you, Your Honor. Ma'am, if you give us your full legal name for the court reporter, please.
Mary Teresa Bunsack,
Can you spell for the benefit of the court reporter your last name, please?
B as in boy, Onceek.
And, thank you, ma'am. Are you related at all to Jerone Hunter?
I am.
And how so?
He's my nephew by my brother.
Okay. Where do you currently live?
I live in Valdosta, Georgia.
And, ma'am, one of the, there's some bigger thing topics I want to get to, but let me just ask you in terms of background. So obviously you're related to Jerone's mother, Annette Washington?
Yes.
Okay. And before Jerone, before brother Alicia and Jerone and Jeremy as well were born, were you aware of, or did you witness any physical abuse from Alicia Sr. on Annette Washington?
Yes.
And on more than one occasion?
Yes, sir.
In more than one city?
Yes.
So over, just roughly, how long of a period of time did you see the physical abuse between the
It was years.
two? And so in terms of locations, where was, what city was the first time you saw this?
It was in Miami.
And was Annette and Alicia Senior living down there at the time?
Yes, sir.
Okay. Were you living with him?
Yes, sir.
Okay. And was there anybody else living in the household at the time?
Yes, I had other siblings as well, and my parents there as well.
So a lot of people in the house?
Yes.
Okay. All right, and then any other physical locations, cities where you saw physical abuse?
It was one home where we live in Miami where a lot of physical abuse happened there. And then we also moved in Carol City. It was also a part of Florida or whatever. And
Let me ask you something that has been what your court will want this. Was it Carroll City that you,
yes,
do you know how to spell Carroll?
yes, sir.
All right, so, and you said this, you saw this over years, was it like physical hitting?
Yes,
Were there times when the police were called?
yes, it were.
Were there, when those times occurred, did Annette go forward with pressing charges against Alicia?
She never pressed charges. She always denied. Or when an officer would come, she wouldn't tell him that he was there, or she would not appoint to them and tell them what happened or anything.
Did you see physical injuries on Annette?
Yes.
And can you generally describe them?
He had black eyes, arms, legs. She even had a broken leg.
Over that period of time of the physical abuse, was there times when Miss Washington, John's mother, would separate from Alicia?
Yes.
Were those times very long?
No, not at all.
Would, did Annette and Alicia get back together?
Yes.
And did that happen more than once?
Yes.
Did you try to keep them apart during that period of time, or separate them, have them move elsewhere?
No, I was young at the time, and she was not hearing what I had to say. I was only like a teenager at the time, so a grown adult don't want to hear from a child.
I will ask your age now. You are younger than me. All right, so let's talk about now, when Alicia was born, Junior.
Mhm.
After he was born, was there still occasions when Alicia Senior would physically abuse him?
Yes,
And did you see that after Alicia was born?
yes, I did.
And what city?
That was in Miami.
Miami. Same residence, same location?
Yes,
Police involved in those occasions?
yes.
Same resolve to press charges? Is that what it was?
Never pressed charges, no.
And we get back together with?
Yes, she will.
Marks, bruises, same thing?
Yes,
After Alicia was born, but before Jeremy and Jerone were born, during that short period of time, did the abuse continue?
yes. Like I say, it continued for years.
And now you're.
All right. Were there occasions when the physical abuse occurred in the presence of Alicia Jr.?
Yes, it did.
Were there any times, just kind of going from now, Alicia Jr. is born, we'll talk about when the other boys were born. Were there times when the Department of Children and Family Services got involved in the physical violence going on in the house and all?
I don't recall them ever getting involved in with anything that happened. Only thing I remember is the police coming out several times, and the mother they would ask, "Is that the person?" And she would deny and say, "No, that's not him."
Okay. So let's kind of take the next step. Jeremy and Jerone are born. Were you around in their lives after they were born?
Yes,
Are we still in Miami at that point?
yes, sir.
Okay.
What kind of feeds?
When the boys, Jerone and Jeremy, are born, did you continue to witness physical abuse by Alicia Senior against Annette?
Yes, I did.
Was that in Miami or somewhere else?
It was still in Miami.
And did that physical abuse after the twins were born occur in your presence more than one time?
Yes, sir, it did.
Still physical injuries on Annette?
Yes,
No DCF involvement, taking the boys away, sheltering them, anything like
no,
that? Police called still after they're born?
yes,
Now, were there occasions after the twins were born where the physical abuse occurred in their presence?
it was always in a present. Yes,
In the household or other places?
inside the house.
And what kind of physical abuse? Was it punching, slapping, kicking, weapons, any descriptive?
I never encountered it, seeing any weapons or anything. It was just like hands, where he would grab her sometimes by the hair or something. And
Focusing on that time frame after the twins were born, when the physical abuse occurred in their presence, the twins' presence, was the abuse ever initiated by Annette? Or was it the other way around?
only thing I would hear, like, it would go from an argument and then to a physical abuse, and that would be. I love my brother, but that would be him striking her, hitting her.
After the twins were born, did Alicia Senior ever get violent with anybody else in their presence?
Yes,
Who else?
he got violent with us, his sibling. Yes,
You as well?
yes.
Punching, kicking, what type of abuse that is?
One time, I recall him coming at me.
Okay. And he struck you?
Yes,
Where were the boys at that time?
they was right there, and that's because we would try to stop what was going on.
Okay. Would the boys try to stop what was going on? It was probably babies.
Only the older one, Alicia, would try to.
You would, Alicia Junior would try to physically stop the fight?
Yes, he was a little boy,
Did
yes.
you guys have any luck in that at all? Stopping the fight?
No, only after we were threatened to call the police or whatever, and then he would either flee the scene or he would, just sit there or whatever because he know that, and that would not tell on him or anything.
How did the twins, particularly Jerone, how did they react, your observations of how they react when there were times when Alicia Senior was abusing you, your siblings, and or the mother?
Well, after so much had went on, he was having dreams, bad dreams and nightmare.
Who was?
Jerone was.
Okay. And tell us a little bit more about that. Was that, well, let me start here. Do you know roughly about how old Jerome would have been at that time?
Yes, he was 2 or 3 years old at the time.
Okay. And we're still in Miami, right?
Yes, sir.
It's on Anchor and Jerone.
And then was he reporting to you about having the dreams and the nightmares, or did you hear him during the night?
We actually seen, hear him cry and scared.
Okay. When you saw that, was he drawn in the bedroom, or where was he at?
He was, I can't explain, because, it was a big den that, he used to be on, and he would be in there, and he would be crying or whatever, and he used to always shake his head like, no.
Jerome did that, shake his head no?
Yes, sir.
Okay. And, is this when, like, is he, what was he like? Is he like waking up in the night, or when he's expressing this, or?
That would be time when he'd wake up and he would, he would shake his head, I don't know, like he telling somebody or something no.
Okay. And was he having any other problems during that time, Jerome? Bedwetting, acting
Yes.
out in other ways, anything like that?
Yes. Well, he was still, he was still pretty young, so, at that time, so yes.
During that period of time when the twins are observing the physical violence with everybody family members, did anybody send them to a counselor, psychologist, get any kind of mental health treatment for Jerome?
No, sir, no.
Did anybody talk about getting treatment? When I say anybody in the family talk about getting him treatment?
No, sir, he did not.
Okay. All right. And then going forward from there, did eventually Annette move from Miami to some other location?
Yes, she did.
Where was that?
That was when they moved out of the home with us and they moved inside their own place.
They being Alicia Senior and Annette?
And the kids, yes.
Okay. And where was that to?
That was in Carol City at the time.
And did they stay there? Let me rephrase that. Did you move up there with them, or did you stay in Miami?
I was still in Miami at the time.
And, did you have, when they moved to Carroll City, did you have much contact with them after that?
Yes, we did. It was like, it was over there like, almost every day.
Okay. Now, had Jeremy passed away by the time they moved to Carroll City?
Yes.
Okay. Before I go on to, let me pause for a minute to ask you about that. So, how was Jerone's personality before Jeremy died? What was he like back then?
Council, can y'all approach for just a moment? I'm gonna have that super loud white noise, I apologize. Wait until she's ready, and then I'll turn it on. Okay, we got it. All right.
Thank you, Sue John.
You absolutely may, Mr. Wood.
So, just in, very quickly, what was, Jerone's personality, what was he like before Jeremy passed away?
He was a happy baby.
And what about after Jeremy died?
Things changed. He, like I say, he always, I would shake his head like telling something or someone no.
Were there occasions when, from your observation, it looked like Jerome was talking to somebody?
Yes,
Did you see that on more than one occasion?
yes,
And then going forward, Carroll City, you continue to stay in contact with Jerome?
yes.
Did you like live up there or just come visit?
I lived there.
And did you continue to see physical abuse during that period of time?
Yes.
On Annette, yourself?
No, it was Annette.
Same activities, getting back together after the abuse, all that?
Yes. My parents sent them away, her away several times, and that would come back, and it would be the same thing.
Get back together.
Yes.
So going forward, well, roughly how long did you stay in Carroll City with it?
At that time, it was only probably 2 or 3 years.
Okay. Did you move from there to some other location?
I think at that time, years had went by, like she finally like realized that I guess had enough.
Okay. Did you move in with them in any other location after Carroll City?
No.
Okay. Now, when you continue to stay in contact with, did you continue to stay in contact with John after you moved away from Carroll City?
No.
Okay. And that would have been, how old would John have been at that point, just to get a reference?
Like I say, he was at that time 2 or 3 years old.
Okay. And for a claim of reference, did you continue to visit or have visitation with Ron after Annette married Dan Wash?
No, we had no contact.
All right. And did you continue to have contact with Alicia Senior after you, in any way, after you moved from Carroll City?
Oh, yes, yes.
Okay. Now, in that context, did, after Carroll City, from your observations, did Alicia Senior have any relationship going forward with Jerone?
No.
All right. And do you know if that's still the case today, that they don't have a relationship?
No relationship, none at all.
Okay. And then, just one second, Judge. Oh, let me, on an economic matter. So, last time you lived together in Carroll City, were either Alicia Senior or Annette working?
Yes, my brother, he were working, I believe at a tie shop or something.
At a wood shop, I'm sorry.
Tie.
Tie.
Hi, thank you.
Okay. How about Annette? Was she working at the time?
No, I don't think, no.
Was she having her own mental health problems?
I believe so, yes,
And what makes you say that?
because of the action. After the physical abuse and everything that you continue to stay in a relationship and do what you do, yeah, you got a problem.
Okay.
And I'm not being funny or anything. I knew that as a child that was too much.
Last question. So going from, well, during the time in Miami, during the time in Carroll City, were there times when there were issues of food coming, having food available, or money in general between Annette and Alicia in the household?
Well, they stayed in our household with our parents, and my parents provide everything for everybody.
And were they providing financial support to them when you guys lived in Carroll City?
No, that's when my brother was working and financially paying whatever bills they had.
Okay. All right, that's all I have. Thank you.
No cross judgment.
All right. Ma'am, thank you very much for your time.
Okay.
Mr. Wood, any additional witnesses,
Yes,
sir?
so I have two things that I want to, did you get them to sign? Okay, just so you know, I just thought it was clear this year. Sign this letter. Because it just said. No, but she's, I know that they all come together. Oh, no, you have this.
Yes,
No, okay.
just sign it. Your family?
Yeah, and then this is the east side of the Judge, I have a couple of letters that I'm going to put in evidence.
Okay, thank you.
Let me. The first one is the email letter from Esan, it's spelled E-S-A-N, Robinson. And Judge, just to tie it in, this is Miss Mayhew's son that testified previously during the penalty phase.
I recall.
He lives in the station in South Korea.
Okay, thank you. I do recall.
I have reviewed that email. I have no objection to that coming in.
Thank you, Mr. Donis.
And then I have a 3-page letter, which I'll describe as a hundred family letter. We did get in contact and Priscilla decided as well that it's labeled Hunter Family. The state has a copy of this as well, and I'd like to put this in.
Mr. Donis, would you like to say anything regarding the letter?
I would. I have no objection to Your Honor considering it. I would just I just want to make sure that it was just signed the Hunter family, the copy that I received. I don't know who authored it, but I understand it's the sentiments of the entire Hunter family. I received it with an envelope, a copy of an envelope from Dallin Anderson from Atlanta, Georgia. But I understand now the copy is provided to the court. Somebody signed today, Ms. Bonsek, who was here in court. Did I hear you say Priscilla also signed it?
Yes.
Lindsay, you have those ones. If you don't mind.
I don't do that.
Thank you.
And Judge, the next document I'll put into evidence, and this is, I'll share this with the court as well.
Can I see the?
Sure. So,
That's all, I just wanted to check.
check to see, it should be like page 9 through 25. And then I'll.
Oh, you have to make that in? Is that what you're saying?
No, I haven't made the minutes, but I did take up the necessary discussions, they had legal discussions and all that, but I do need to get a marker and make that.
Okay.
If you, I can do it simultaneously, just let me know what page and.
Yeah, sure.
Aggravated battery.
That's the scene was.
Yeah, exactly. I'm like, honestly,
So like,
they're just making it heavier.
them close to that.
Yeah.
Okay, I found it. It was just page 13, lines 5 through 7.
Five through 7?
So I know there's, that's okay. I don't mind that coming in.
Mm-hmm.
And then the only other thing was 17 and 18, just the question, lines 21 through 22. The answer was fine because they don't really answer the question there.
What line?
21 through 22.
I see what you're saying.
But the answer.
More than exactly
answer.
response. Yeah.
Right, so I don't know.
So I'm gonna mark redacted on the top.
That was- All right, so, Mr. Wood, let me ask you this, and actually, Lindsay asked our clerk, do you want these just marked, or do you want them admitted into evidence as an exhibit? How would you like that done?
Exhibits.
Okay, so it'll be, we'll have them listed as exhibits then, and admitted. Thank you.
Judge, the next proposed exhibit, and I've provided a copy to the state. First, let me say these are transcripts from the original Spencer hearing before Judge Parsons,
Yes, sir.
August 28, 2006. Before any redactions, I took out some pages that dealt with legal argument before the witnesses.
I understand.
And for the record, the testimony, and then also some language afterwards. Morris Hunter, Teresa Horn, Janie Brown, Annette Washington are all contained in these transcripts. Now, there were two redactions that I agreed to make that the state was going to object to. You'll see them marking on here, and simply put, it's, there are two witnesses that asked the court to sentence Jerone to life, which there's a case, particularly the Burns case. It works both ways to either side.
I was gonna say, if Mr. Donis isn't objecting then to the form,
No, I objected to that portion, but he just crossed it out, and I'm perfectly okay. I understand you can set it aside, so that's why we didn't formally redact it other than just crossing it out.
okay, gotcha.
Yeah. And I guess I'll put on the record too, so what we're talking about as far as reduction is page 13, lines 5 through 7, and the other ones on page 17, lines 21 and 22. So, and I put redacted on top, Judge.
Thank you very much, and that would be, thank you.
I'm going to have a couple of demonstrative exhibits in just a moment, but I think the next up would be an allocution from my client, Mr. Hunter.
Yes, sir.
Where would you like Mr. Hunter to?
Thank you very much.
Just go in like a 5-minute break before we do the allocution.
Well, this might probably be a good time for lunch. It's almost noon.
Okay.
So I wasn't sure how much longer you were looking to go. If you're not gonna go that much longer, we can push through lunch, which I'm okay with, but I need to give Miss Salmon some time. And I know she's not anticipating taking a lot of time, but how long, and I don't wanna rush anybody, please understand. How much longer are you thinking?
Oh, probably 20, 25 minutes.
We're gonna break for lunch then. All right. Okay, we'll be back at 1 o'clock.
Okay.
Thank you.
All right.
Your Honor, unmute just real quick so I can just give him a message.
Yes, absolutely. Yeah.
I want a chance to speak with him, please, but I'm letting him
Yeah,
know.
let him know. Yeah.
Yes. Troy, can you hear me? We're working on getting you a copy. I'm trying. So now that we're taking a lunch break, maybe that'll give me enough time to get someone to agree to print something for me. Okay? So we're working on it. Okay? If not, I'll do it. All right.
Thank you. All right, it may be best that we'll work out for lunch, so.
Probably.
All right, okay, we'll be back at 1 o'clock.
All rise. We'll probably just go upstairs or just hang out. I am legal. No, I'll just install it. You got
trial, 06, and then now,
good.
number of times.
Yeah.
That's what it
He's
is.
gonna be on the stand, so.
Okay.
Yeah. No, I don't have an objection.
Alex calling right now from our station. With the SD card machine to recording everything SD card because they need everything the packet from home.
Oh, no, disconnected.
I know. You have to move back over somewhere. So look out for that.
I do not. I don't remember the charge or what happened to it. I remember he got arrested for battery or something. Oh, maybe that's the act I was talking about. But I don't know honestly what happened to it or why.
You know, it could be a requirement that you guys will have a t-shirt. Take a t-shirt.
Yeah, so you're like, okay, this is a reprieve from that.
Hey, speed's back up on 14.
So it sounds like he didn't need to.
Did you have lunch? Hello.
Love to see money. Yeah, hashtag has fun. Right.
I thought we had an all-staff meeting the other day. I thought at first.
Demi told me about that.
What?
Demi told me about
At
that.
first I thought it was
Oh, really?
the rumor mill has been like a very close. I don't know who. But
Yeah.
we've heard they're very close. So we thought that was what it was going to be. But then we're like, oh no, baseball. That's not.
Yeah. She told me the other day when I saw her, she was like, yeah, we all just basically got yelled at.
I mean, listen, you need to get the message through, and then we get 21 mistakes today or yesterday, which is where we usually have. So.
Yeah.
But Mace was 30 minutes. I think the ratings are going up again.
There you go.
So.
We get to see our station.
Every 76 years.
Stop, probably 2 or 3 years ago, giving all that TV. Like, they do care about it, but it's like our website is digital, is everything.
Right, you know when the whole digital thing first came on the platform, we had a whole department, photographers, writers, everybody for that.
Right.
But then they came and they go, oh, we don't need that, you don't need that.
That's
We're
what we
like, what are you
got.
doing?
Doesn't make enough money.
I know, we think that we would all transition to just to that.
That's our station is.
Digital money. Sure.
Right.
Maybe a little bit more than that now.
Oh my god. You know, we are all about digital.
It's driving me nuts now.
Don't sleep until you find it.
Start channeling yachts and thinking.
Where's that?
They used to laugh, they're done.
Well, they probably overall.
Grandma died. Debbie didn't tell you what you did yesterday? In our group text with Pam, Pam doesn't have the rest of the week, and I read that like, oh, something bad must have happened. And I was like, oh, hope everything's okay. And Debbie just responded, you lucky bitch.
That's what I was just looking for.
Pam comes back like 2 hours later, my grandma died.
And make sure you got it.
Oh my god. You always assume because you're off, it's
Dude,
peaches and.
I was laughing so hard at that. Oh my god.
You should see that right there.
There's a camera in there.
What?
See on the top, it's like a.
Oh my God.
We don't have a camera.
Face.
The guy that, he's trying to break it right there.
Who's your other guy, just sleeping?
Who?
Or he's not?
They're pushing him out now.
Okay.
It accidentally hit me, so there's 8, two main ones, 6 people have them to get that call. It took almost 2 years to get it, left to get it down to probation. And, it was 8 counts of active. The issue was whether there was present. None of them was here. Well,
Isn't Warren supposed to court photo out?
Yeah, they're gonna start being like, ooh, sin, Nick.
I don't mind it,
It's the same ingredient.
I can do it, it's just.
Well, they couldn't prove.
Big one.
It's not a big story, like, you have a questionable murder in my county, it's the fact that somebody drove an excavator.
I did so good. Ian wrote that letter on the side.
It's good.
It's good.
Get some good drone shots over there, please.
Yeah, I just put up all the photos, and I'm glad that our team is still like, just a little crappy ground photo.
Oh,
We know, Zeke's been there, he's been flying his drone, we know that.
Yeah.
So,
did you guys send the crew?
yeah, the crew's been there, since I think he got the call. So
Yeah, this morning.
He was about before the 9:30 meeting. For this,
Yeah.
So,
All you gotta do when you're flying your drone, there's a little button on the top right, has a little camera. While you're shooting video, you just press that and it takes JPEG stills. So when you download it, you send the JPEGs to the station, because they don't like to pull frames from your video. You just send those aerials.
We should definitely
it
look
could
at
just be
your
the web
story.
team is not caring right now, there's got a lot going on, and they're understaffed.
It's definitely one of the weirdest stories. So. It's so good.
Let's get physical, physical. Wanna get physical. Move your body.
That's the mic apparently. Is that Wesh's mic?
Yeah, that's your house.
Who? Cool. No, nothing's on right now.
That mic is going live feed.
When they're in session.
No, we're all live right now.
Why? Whatever. What are you doing this weekend?
All right. Circuit Court now come back to order.
All right, everyone, please be seated. Mr. Wood? Right there's fine. He's fine sitting there if he's comfortable sitting there.
Okay. let's,
You okay with that?
Let me make sure that,
Okay.
yeah.
We'll make sure we'll have the mic for him.
Just keep it conceptual, too. May I proceed, John?
Absolutely.
Okay. Let me put on the record, you are Jerone Hunter? Yes?
Yes.
Okay. Mr. Hunter, you have a statement before you that would you like to read that statement to the court, to the judge?
Yes.
Okay. You'll go ahead, please, sir.
Sit, I'll talk.
Back in August of 2004, I was part of something that destroyed a lot of lives. And for that, I'm truly sorry for all the pain, heartache, and trauma. The families I know, the hurt of tragic loss, and I regret every moment of my actions that took your loved ones from you. I'm truly sorry for the pain my actions has caused. I know my words of remorse and apologies can't change anything. And I want you to know that I understand the impact of those events that has been a dark cloud over the community for the last 2 decades. These words can't really give meaning to how sorry I am for my role in those unnecessary killings. That wasn't my intentions that night, and I don't know how it got to that point. Through the years, I've worked on my mental and emotional issues through meditation, which allows spiritual growth and self-awareness. I really want to be able to have a positive impact in this world, to help someone become a better person, to pass on positivity to the next person that may be struggling in life without direction. I understand the significant impact and devastation those murders has caused family, friends, and the entire community, including my own family and friends, because of my actions that night. No matter the reason, there's no excuse for what happened. I'm extremely sorry to the families, friends, and community as a whole. Words truly can't express. During that time, I was a young, weak-minded idiot that made the most horrible choices. Not everything that was presented was true, but no matter the details, 6 people lost their lives and other lives were destroyed. There's no going back from that. Beyond whatever happens with sentencing, I want to be a positive influence in someone's life, making a positive impact in some way. To my family and friends, I'm sorry for all the negative things that you've had to endure because of my actions. I wish I could have been a better person in your lives.
Thank you.
Thank you, Judge. Thank you, Judge. Judge, I think it might be, you should probably put a copy, put the original in, save a copy. Judge, if I may ask the clerk to, as an exhibit,
Yes,
file the original, and would ask for a copy back for our records.
we can do that. Thank you.
Maybe, follow up with some additional last documents to put before the court.
Yes, sir.
The first one, it's a 2-page document. I just did the font a little bit. It's a demonstrative exhibit, instances of the state using the N word, and it's a page and a half actually. And I would like, and I know we're going to be incorporating this into the our sentencing memo, our arguments, but because it's, I think, also appropriate to put this in to relay instances of in the transcripts of the proceedings, put this in as the next exhibit. I don't believe to say we're going to do an objection.
So admitted.
Judge, the next exhibit I would put in would be there is a single-page graph. It's titled Florida Executions by Age and Type of Offense. Cites some information, some graphs in for the court for sentencing, but again, because it refers to data, I wanted to put this in the Spencer hearing, and I do believe the state has an objection. I'll be glad to respond to the objection.
State's objection.
And I understand you may need to review it to make a decision, but
Can I see it?
it's the state's position that this is irrelevant to your determination as to what is an appropriate sentence in this case. It's a chart talking about the number of people executed in Florida by age at time of the offense, and then at the bottom it mentions 2 gentlemen, and they happen to be black. So it's the state's position this is irrelevant for the court's consideration, and it should not be admitted.
All right. It's admitted over the state's objection.
Thank you, Lauren. And lastly, let me get Judge, I would, as a composite, the next and last proposed exhibit for Mr. Hunter, there was mention of this, this has come up in previous occasions. So Mr. Victorino, in case 2004-13-16, was charged with felony battery for an incident that occurred July 28th of 2004. I have the information, I have the docket that shows it was Norfolk, but the reason we're asking that it be an exhibit for the court's consideration and sentencing, not that it's an aggravator, in fact, it'd be a mitigator to support Mr. Hunter's argument about being under the influence and dominion of Mr. Victorino, and being a fear of Mr. Victorino at the time of the murder. So we would like to put this as an exhibit for the court's consideration. And again, we'll be filing a sentencing memorandum that'll include this information.
I have no objection.
So admitted.
Judge, I don't have anything else.
All right, thank you. And I know that the sentencing memoranda will be coming, and I'll be on the lookout for them.
Yes, ma'am.
Any argument, or do you want to wait until the end and I have everybody present their argument?
I can do argument after Mr. Victorino is concluded.
Okay, all right, thank you. Ms. Sammons.
Thank you, Your Honor. I am attempting to I'm just going to be putting in some exhibits, Your Honor, and then I'm going to ask for Mr. Victorino's video to be turned on at this point.
Yes, please. Oh, is he not? It's on?
The prison needs to turn it on then?
Yeah.
Because I need to make sure that he can hear and see me because I have to ask him questions.
Certainly.
And they need to unmute him as well.
All right, thank you.
So I think I think we have to wait until we know
Oh,
he's there.
absolutely, that's fine. So I'm going to step off the bench and go down the hall, and by the time I get halfway there, I'm sure it will, does it look like it's popping up now?
They unmuted him, so
Okay, great.
there we go. It
You
looks
just
like.
have to threaten you're going to get off the bench.
That's it, right?
That's it.
Thank you.
Okay, all right.
Mr. Victorino, can you see me?
Yeah.
I'm waving. And you can hear me, obviously, because you just responded to that. Thank you.
Yes, ma'am.
Okay. So, Your Honor, the additional exhibits that I want to enter, the first is a letter. The year is very difficult to read, but it was associated with one of Mr. Victorino's juvenile cases in which he was sentenced as an adult. It's dated September 21st, 1990. I'm going to guess 7 or 8. But this is authored by Sharon Victorino to the court, and it is part of the court file. So the state does not have any objection to it being entered. It is basically the most important part, Your Honor, would be what I think for the court is the fact that Ms. Victorino on pages, really it looks like the third and fourth page, describe his prior abuse. So this was basically to indicate that there was Ms. Victorino had indicated that there was abuse and neglect and issues like that way prior to the homicides occurring in this case. So if I may approach the clerk and admit
You may. No objection?
No objection, Your Honor. I would ask you to disregard the stuff. You'll see when you read it, she talks about a study, juvenile criminals treated differently by race. But obviously, all the stuff about the history of the abuse and her opinions on that, I have no objection to.
Thank you.
And that is why I wanted to preface the reason why I wanted to, because obviously a lot of that data is stale now. This is from the 90s, so it's not necessarily relevant for our purposes at this point.
Thank you. Straight in is fine. Thank you. And then, yes, thank you.
All right. The next document that I wanted to enter into evidence is Mr. Victorino's DC-14. It is dated as of August 14th, 2024. I did request an updated one, however, did not receive it in time for the hearing today. However, I may supplement the record with the additional one prior to the actual sentencing hearing, because I know that it will reflect the same exact data, which is that he has not had any disciplinary reports, especially since 2024, but basically since he's been incarcerated on this case. But he has some priors from when he was incarcerated before, which were testified to and explained by Mr. Bonasco, the expert that we presented at the trial. And I know the state doesn't have any objection. It is a public record.
Okay, so admitted. Straight in.
And the last I have, Your Honor, the state does have some objection to, is a letter dated July 11th, 2025 from Antonio Victorino, who is Mr. Victorino's brother. The only portions that they are objecting to are, I believe, where he indicates in paragraph 1, 2, 3, 4, 5, let's see, that they wanted to, actually no, it's
I can
6.
just read it if you
Yes.
want the specific lines.
Mm-hmm.
There are 2 areas, Judge. Please allow me and my family to have just a little more time with this new version of Troy. And then lastly, I know that I have no right to ask, but I do implore you to please be lenient with him. Allow us and others to more fully get to know this version of him. Please extend your mercy towards Troy. And the state's objection, did you want to speak first?
No, you can.
Yes, my objection is, it's not relevant to your determination of sentencing what family members on both sides want to have happen. That's not an aggravator or mitigator. I understand her position is different.
Our position is just that it's a request for mercy, which is going to be echoing what I'm going to be arguing anyway in the sentencing. I know that Your Honor can discern what he means by this. It would be strange for him to be asking for a different penalty other than a life sentence. So I think that it kind of, and in front of a jury, I understand that would be inappropriate out in front of the court. I don't necessarily think that you can't discern the difference between those two things.
It's admitted over the state's objection.
Thank you.
Straight in.
And I know that I wanted to read it mainly because my client is not here, and I wanted him to hear it.
Okay.
And so if I may, unlike the others, it's only one letter, Your Honor, and it's 1 page, so it will not take up too much time. But I wanted Troy to hear this from his brother. To whom it may concern, I would like to thank you for the chance I have to express my feelings in regard to my brother, Troy Victorino. As the 3rd child in my family, I was able to spend some time with my brother as children and in between incarceration periods. Looking back, I can honestly say it was nowhere near enough time. Growing up as I am, sure you have heard, Troy was the protector. So much so that it wasn't until after he was gone and the negative attention started being focused on the rest of us that I began to realize how dysfunctional our family dynamic was. And so as a child, I wanted to escape not just my house, but my family as well. I say this because it is only now that I am in my 40s that I realize just what our trauma did to us and how hard we had to fight to survive and appear normal. This was especially true for Troy. I have personally seen the shell that he wore to protect himself fall away, so to speak, as if he literally shed his skin or changed his clothes. I listen in on the weekly conversations he has with my mother and younger brother, and am amazed by the genuine concern and comfort he shows to them. My own interactions with him, though limited, are now refreshing and something to look forward to, as opposed to the draining effect they once had. I share this with you because the Troy that stands in front of you today, I know, is different. I no longer want to hide the fact that we are related. Instead, I speak often of it and how he has changed so much. I know that the things that have been done cannot be undone. There has been such a loss of life, and that gift is ever so precious. I am not asking for forgiveness, but for mercy, please. Please allow me and my family to have just a little more time with this new version of Troy. As we draw closer, we continue to heal from old wounds cast upon us, and I continue to see these wonderful layers of my brother that I never knew existed. I get to hear expressions of how instead of fear of him, people are touched by the joy he can share with them. I know that I have no right to ask, but I do implore you, please be lenient with him. Allow us and others to more fully get to know this version of him. Please extend your mercy towards Troy. Regards, Antonio Victorino.
Thank you. Thank you.
And then, Your Honor, and if I may get up my water, please, just briefly.
Certainly.
I'm sure Your Honor noticed I was going in and out a lot. I was attempting, because Mr. Victorino had provided me with his copy of his allocution. I wanted to review it to make sure it was appropriate, make any edits that I wanted to make, or suggestions, which I've discussed with him over the break. The problem is that that was his only copy, and I've been attempting to get the Department of Corrections during these past couple hours to print something out for him so he could read it himself. They have indicated to me that security will not allow it.
Okay.
So I am asking to read it for him.
Hearing no objection from the state, you may read it.
I am going to, of course, show it to him so he can authenticate it as his handwriting.
Certainly.
Except for the blue, which is mine.
Okay.
Troy, I know that it's going to be hard to see this. I don't even think that I can actually get it, but did you provide me with a one-page letter that is handwritten? Did you?
Yes.
Yes. Can you hear me?
Yes.
Okay. You see that I'm holding it up? I know that you can't see this, but it's a one-page letter that starts "To whom it may concern" and signed humbly Troy Victorino.
Yes.
Okay, and then we discussed when we were talking earlier, some of the edits that I had. And I had added those of blue ink of things you wanted me to add or change.
Correct.
Yes, sir.
Yes, ma'am.
Do you have any objection? I know that you can't, but is it okay if I read this for you?
Please. Please do.
It sounds like it might be better anyway, because it seems like the volume over there is a little bit hard to hear. Okay. So, for Your Honor, this are Mr. Victorino's words. To whom it may concern, thank you for your time. I've spent the last 32 to 33 years of my life never accepting responsibility for my actions and behavior. I lied because I was scared to lose my family. Finding my faith fundamentally has changed who I am as a man and human being. Because of this, I am deeply saddened and sorry for the tragic, unnecessary loss of human lives. This crime was horrible and could not ever be justified. Nothing I say will ever make things better or fix the emptiness of the loss of Aaron Belanger, Francisco Ayorman, Anthony Vega, Michelle Ann Nathan, Jonathan Gleason, and Roberto Gonzalez. Their absence in the world is so noticed and cannot ever be replaced. Any good that I have done since finding my faith is a credit to them. My search is not for freedom, but for forgiveness. Spending my life showing others that they can change for the better, that they can be positive, productive, caring, and compassionate is on behalf of the victims and myself. This tragic loss gains nothing by adding more families to the list of victims. It gains everything by any positive, hopeful act that can be done on my behalf for Aaron Belanger, Francisco Ayorman, Anthony Vega, Michelle Ann Nathan, Jonathan Gleason, and Roberto Gonzalez. I ask and hope this court will allow me to continue to do everything and anything I can on behalf of the victims. Thank you for your time and consideration. Humbly, Troy Victorino.
Thank you.
And Your Honor, that's the end of the presentation that I have.
Thank you.
So the only thing I have left is a very brief argument. I am reserving the vast majority of my argument for the sentencing memo, which I've already started to work on, which is where a lot of this is coming from. Do not worry, I'm not going to read everything I have here. I just wanted to basically highlight, I think that it was clear that this presentation of evidence was a little bit different than in the first case.
Yes.
The reason why is because, frankly, so much time has gone by. Troy Victorino is 48 years old today. He was 27 years old on the day of the Telford murders. Time does not heal wounds. It does not change those things. But what it does is reveal who you can be and who you are. The Troy Victorino of 27 years old was immature and childish and refusing to accept any responsibility for what he did. He was someone who scared people, as was made very clear in the motion to sever. There was fear surrounding him. I think that what we were able to present over the course in front of the jury was that, and I hope that many of them saw that, was that he fundamentally was a very flawed and broken person who used what he looked like and his strength in order to put on a very different front than what was inside, which was a child who had been abused, neglected, and quite frankly, even though loved by his mother, he had a very dysfunctional home life. It's not often, and I would ask, well, once again, we have records that were put into evidence, and I will refer to those in my sentencing memo, but it's not often that we see children who are hospitalized at a young age. His trajectory was damaged from the beginning, and once again, we're not providing any sort of excuses for why we're here. It is an explanation for how someone like Troy could get to this point. But one of the biggest differences between the prior sentencing presentation and this one is that Mr. Victorino has accepted responsibility. He continues to strive to continue to do that every day. He is a very good inmate. He has made differences in people's lives there. You've heard from those inmates. So the highlighting of what we're talking about here is who is he now versus who was he then, and is this somebody who should be subjected to the death penalty, or is it something that you should consider for a life sentence, despite, of course, the jury's recommendation, which I would remind the court is not unanimous. I've already filed motions to stay because of kind of pending litigation in Florida Supreme Court, where we have not heard yet on the Michael Jackson case, which I believe would have a direct impact on not only Mr. Victorino's case, but Mr. Hunter's. So, and those are things that I will argue in my sentencing memo as well. But I think that because these are not unanimous, because of how long this has been going on for, and the changes that you have seen and that we have proven have happened with Mr. Victorino, that make him so different from that person when he was 27 years old, that is the basis for what we're going to be asking for you to consider a life sentence for him. And of course, I will be very detailed in our mitigating factors and describe which experts presented which facts. But it's clear that he has family support and love. There are people who care for him and continue to care for him. And while there's no way that we could ever speak for the victims in any way, the finality of a life sentence, I think, would be, or I would propose, would be very healing. Mr. Victorino would die in prison, and despite any litigation, any future litigation or any future jurisprudence from the United States Supreme Court or from the Florida Supreme Court, it will not affect him if he was sentenced to life. It would be over, and I think that at this point, who he is now, while he never earned it before, I believe that that should be considered now for a life sentence, Your Honor. And of course, I will reserve the remainder of my argument.
Thank you very much.
Thank you.
Mr. Wood.
Thank you. I do have some summation in writing I wanted to go over, but again, also we will have a more, do we have tissue?
Sure.
Great. We'll have a great deal more one in our sentencing than grab away. I appreciate the opportunity to do some summation here. The court has an awesome responsibility, certainly at this phase in the proceedings, in consideration of, as we asked for the court to override the jury's 4 verdicts on the 4 separate verdicts of death the jury has filed in this case. The 2 main things that we will be dealing with both today and in the sentencing memorandum in terms of mitigation, although there's numerous other points we'll bring out in the memo, is if Mr. Hunter had been, if the crimes had been committed 66 days earlier than they were, Mr. Hunter would be constitutionally unable to be sentenced to death for these crimes. He was 18 years old and 66 days at the time of the offense. He was the youngest of the 4 defendants in this case, 2 of which have already received life sentences, Mr. Salas and Mr. Cannon. But as I pointed out in my summation and at sentencing, the number one, I moved it up, the number one mitigating factor in Mr. Hunter's favor is his age. And the second, in terms of order, as again I argued in resentencing, was that he was under the domination of
Mr. Victorino, who's an older, 10 years older, significantly larger gentleman, believe was around 300 pounds. Mr. Hunter was around 130, according to his coach. The research shows that Jerone possessed the same psychological attributes that the Supreme Court has categorically barred in death penalty cases and for mandatory life without the possibility of parole for juveniles, for youths that would be 2 months younger than him at the time of the crime. And I refer to Roper v. Simmons and Miller v. Alabama. Again, these will be in the sentencing memorandum. I should also point out the state of Florida has never executed somebody that was as young as Jerone at the time he committed his crimes. And you'll see that, you do see that in the Exhibit A that has been filed here today. Previously, when the Supreme Court did proportionality review, youth was repeatedly cited by the Florida Supreme Court in granting proportionality relief. Research shows that juveniles are constitutionally different while adults in than adults in 3 ways, and thus ineligible for the death penalty and even mandatory life without the possibility of parole. Juveniles have an undeveloped sense of responsibility, which leads to recklessness, impulsivity, and heedless risk-taking. Juveniles are more easily rehabilitated as their character hasn't fully formed yet. And most important here, juveniles are more vulnerable to external influence and peer pressure than adults. Teens are more likely than adults to be dominated, manipulated, or encouraged, especially by peers of older adults. Research indisputably shows that these 3 characteristics apply to 18-year-olds. I refer to the American Psychological Association, which passed in 2022. Again, this will be in our memo. A resolution supporting the view that 18 to 20-year-olds should not be subject to the death penalty for the same reasons as juveniles. And we had previously, it's in the docket, filed in a Roper extension asking the court to consider the death penalty unconstitutional for persons under the age of 21. The court had entered a denial on that motion, but we do preserve that argument. In the AMA, or the APA rather, has recognized the binary between juveniles under the age of 18 and adults over 18 as a legal fiction that does not reflect adolescent development. One of the powerful parts of Jerone's case for life is the intersection of his youth with Troy Victorino's domination and pattern of exerting violent pressure on everyone around him. And I do want to point out to the court that I personally have asserted the domination mitigator, statutory mitigation. Mr. Hunter has been concerned about this assertion and did not want it to be involved in the potential execution of another human being. But I believe that it is extremely important for my zealous representation of Mr. Hunter to make sure that this mitigator is front and center for the court to review and the evidence that's attributable to it. So I want the court to know that this is my strategy and my strategy alone on that particular issue. Despite or as a supplement to his allocution here today, the evidence, some of which the jury saw and some that they did not, establishes an extreme power of imbalance between Mr. Victorino, Jerone, and the other teens involved in this crime. Age disparity, again, Mr. Victorino was 28 at the time, Jerone was 18, and Robert and Michael were also, Robert Cannon and Michael Salas were also 18, just months older. Significant size disparity, Mr. Victorino is 6'7". Jerone is 14 inches shorter than him at 5'5", and the two other teens were much shorter too than Mr. Victorino. Even setting aside the power disparity between the size of Mr. Victorino and Mr. Hunter as a teenage boy, the record shows that all three co-defendants and Brandon Graham and even that these were all much younger individuals than Mr. Victorino, and they expressed fear of Mr. Victorino for his violence, erratic nature, and alleged affiliations. And we'll cite the specifics in the sentencing memorandum. You also, of course, have heard the readbacks from Mr. Salas that he feared Mr. Victorino would kill him and his family. He testified to that in 2006. Mr. Salas, of course, refused to testify in this case and actually was held in contempt for not doing so. Brandon Graham testified that he was, and he repeatedly said he was afraid of Mr. Victorino because of his size. And Mr. Victorino said he wanted to kill people and he feared that he, Mr. Graham, would be next. Mr. Hunter, of course, testified in 2006, and it was replayed for the court in the readback, that he feared for his life because Mr. Victorino was angry and constantly speaks about everybody that is against him and was physically intimidated, particularly when Mr. Victorino played with his gun while speaking about people disrespecting him. On the 28th of July of 2004, days before the murder, while Hunter was living with Victorino, Victorino assaulted a man and was arrested for felony battery. We put that into evidence. In the summation for this trial, the state conceded that Mr. Victorino is manipulative. Yes, he's the one who's getting this group together and coming up with the plan. The evidence established there was a related mitigating circumstance that Jerone was under extreme duress and under the substantial domination of another person, and that he not only feared Mr. Victorino, but he also depended on Mr. Victorino for his housing. As the state conceded, Mr. Victorino got the boys together and presented this plan. Where an adult may have been able to resist these pressures, Jerone could not due to his adolescent state and psychological development. The point of this evidence is not to argue this court should create a categorical exemption for all 18-year-olds, but the court must strongly consider Jerone's psychological development when making an individualized sentencing determination. If Jerone was just 67 days older when this crime was committed, he would not be eligible for the death penalty. For that reason, and the other mitigation that we will present in our sentencing argument, have argued, we are certainly asking the court to take mercy and sentence Mr. Hunter to life. We are concerned, I know we've raised this in our chart, about the possibility of racial bias in the case. That certainly, and we'll cite the case law that talks about it in our memo, but when racial bias taints capital trials, courts do everything in their authority to take corrective action. The death penalty itself is disproportionately punishes black men for killing white victims, especially white women. As a result, the law says racial bias can play no role in a capital trial. But here, racism and racial bias likely did play a role in Jerone Hunter's death recommendation.
May I ask, is this a summary or is this your sentencing memorandum?
This is my summary.
Okay.
We'll have much more because we're going to break down the myths and the both statutory and non-statutory in our sentencing memorandum. We'll show in the sentencing memorandum, we'll talk about the racial bias and break that down. We do point out in summation that that there were 4 co-defendants, 2 were black, 2 were non-black. The original trial, the 2 black co-defendants received death sentences, the non-black defendants received life sentences. We'll talk more about that in the racial bias and the impact on this case in our sentencing memorandum. Jerone hadn't even finished the high school when his involvement in this murders take place. His brother which he had a close relationship, left the house. He was left with his family. You've heard testimony about the effects that Alicia Jr. leaving the house had on him, the treatment he received from his stepfather, the treatment he received from his natural father. We'll certainly again outline that in our sentencing memorandum. But there is, and we'll break down we had 53 mitigators cited in our summation, and we will emphasize the facts that support the testimony that supports each one of them. This court, again, has the awesome power and authority in deciding whether to override the jury's verdict in this case. We would ask not only the court show mercy with regard to overriding the jury's verdict, but we also point, as does Ms. Sammons on behalf of Mr. Victorino, that there was non-unanimity in the verdict from the jury, and we believe our position is that constitutionally and as well as the mitigation allows this court to rightfully sentence Mr. Hunter to 4 life sentences. Thank you for the opportunity.
Yes, sir. Thank you very much. Ms. Trigonis, did you want to?
No, Your Honor, we'll save our argument for the sentencing memo.
All right, very good. All right, then, so let me ask you this. Anything else we need to address?
Yeah, I think just incredibly briefly, I'm just going to renew the arguments that I made in the motion to sever, because a great deal of that presentation, Victorino, intimidating, dominating, all those things, and it's very difficult to have, to feel like I can't respond to that because these are individualized sentencings. So that's Mr. Jerone's mitigation. He absolutely should be putting, or Mr. Hunter's mitigation, he absolutely should put that on. It's not an aggravating factor on Mr. Victorino, but it feels like one, so I'm going to probably respond in great detail in the sentencing memoranda, but I have to renew the motion to sever after that argument.
Absolutely, Ms. Sammons, and I understand your position. I'm going to respectfully deny it, and I expect that you'll cover it very well in your sentencing memorandum. Okay, thank you. All right, so nothing else for today. What I'm going to do is I'm going to direct Michelle, my JA, to get with you all, because I know that there's a date coming up where I'm going to be receiving the sentencing memoranda from all of you. 25th. Right, and so she'll get with you all to coordinate hearing time on the sentencing. I do want to have the opportunity to review those memoranda in depth. And so I'll direct her. When do y'all think, just month-wise, just based on your calendars, because I know some of you have very busy calendars, and if anybody has any vacations coming up.
I am out of the country 3 weeks in October.
Okay, so October's out.
I was hoping September. September,
Okay, you're open completely in September.
So am I.
Are you? Okay, and
What month are we talking about?
September?
Yeah, let's do that.
All right, so September it will be. So Michelle's going to have to get a little bit creative because I believe I've got some trial weeks coming up in September, but I will get with her. Let me ask you this. How much time do you think you all will need? Because I want to make sure you have sufficient time.
I don't think we present anything at the sentencing.
No, that's right, you're right, so it's you're absolutely correct.
So I suppose how much time do you need to?
That's
review
correct.
and-
All right, so I'm gonna get with her and I'll make sure it's all coordinated, obviously. And let me ask you this with respect to presence at sentencing.
They're required to be present. I think that physical presence is required in a position.
All right. So I'll make sure that Michelle has those transport orders done, and I'll have her coordinate everything.
As
And
close in time to these sentencing hearings, we can transport them, because I don't want them sitting here if I don't have to. Because he's
Very-
closer, they're closer, well, the district attorney's closer to me in my office.
Okay.
Where I am,
all right,
in Union.
all right, I'll do everything I can to accommodate. All right.
And Judge, if the court minutes could also reflect that Mr. Hunter is asking me to go back immediately to the DOC. We
I will
obviously
TOT to DOC, and that's done. Okay. All right. Thank you all very much.
Thank you.
It sounds like they're